Come on Monday.
On Monday.
All mentioning on Monday.
Criminal revision matter. You motion my lord.
Only. Come on Monday.
Inclusion in that.
Everything would be on Monday. No mentioning in this week. Already list is there.
My lord, just fix it on Monday, my lord.
I will fix the Monday, dispose of on Tuesday. No issue. Okay.
Because that week there might be holidays. That's why, my lord. Kindly.
Holiday is the one day. Wednesday or Thursday.
Kindly.
I am there. I will dispose of all the matters. Nothing. If you are ready, I can dispose of all the matters.
Let's kindly fix the matter Tuesday.
No, just mention it. I will fix the Tuesday. Come on Monday. No issue. I will dispose of that matter. All the matters.
Inclusion in the list, your lordship.
Everything on Monday.
Only one matter, lordship, bail in connection with that. The appellant is in custody, lordship.
Come on Monday. What is the hurry? He is in custody. Come on Monday. I will dispose on Tuesday. Okay. No issue. Okay. This matter appears for correction. The CRR number of order dated 2nd April 2024 should be read as CRR 38 of 2024 instead of CRR 38 of 2023. The remaining portion of the order would be unaltered.
Please, your lordship. I am in VC, my lord.
My learned senior counsel, Mr. Devashish Sinha, appears to VC, my lord.
Okay, proceed.
My lord, this is an unfortunate matter, my lord, wherein the sister-in-law, father-in-law, mother-in-law, and the husband has been enticed in a criminal proceedings of 498A, along with the other relevant sections, my lord. My lord, it culminates out of the Siliguri police station case number 73 of 2022, women's police station case number. My lord, in this particular matter, one of the particular petitioner wherein she was also enticed as the accused was quashed by this honorable court by the judgment of a coordinate bench of your lordship also. My lord, actually the allegations are omnibus and the allegations are vaguest of vague, my lord, if I am permitted to say. My lord, in this context, my lord, this cannot continue for a single day, my lord, according to my humble and respectful submission before your lordship, and this would turn into a weapon of harassment, my lord. My lord, the entire allegations, there is no allegation, specific allegation against the father-in-law, against the mother-in-law, that they said you have to cut vegetables, do home chores. My lord, can you tell me? Am I audible, my lord?
Yes, who is petitioner number 1?
My lord, petitioner number 1 is the father-in-law.
And petitioner number 2?
Is the mother-in-law, my lord.
Okay.
My lord, the entire thing took place in Singapore, and that is between the husband and wife. The wife comes to Siliguri and merrily lodges a complaint, my lord.
Okay, hard. Please take down. The instant criminal revision has been preferred under section 482 of the Code of Criminal Procedure for quashing a criminal proceeding. Being GR case number 22146 of 2022 under section 498A, read with section 4 of Dowry Prohibition Act, arising out of Siliguri Omen Police Station case number 73 of 2022 dated 12/5/2022, wherein the charge sheet has been submitted against the present petitioners under section 498A, read with section 4 of Dowry Prohibition Act. Stop. The learned advocate for the petitioner submits that the present petitioner number 1 is the father-in-law and the present petitioner number 2 is the mother-in-law of the opposite party number 2. Stop. He submits that the opposite party number 2 has lodged a written complaint with fictitious and false statement only to harass the present petitioners. Stop. He further submits that the present petitioner, being the father-in-law and mother-in-law, were not anyway involved in the alleged offense. He again pointed out that one of the co-accused of this case has preferred a quashing application before a coordinate bench of this court, and the prayer of the co-accused has been allowed and the case against him was allowed and the case against him has been
Hard.
right order dated 29/8/2023 in CRR number 125 of 2023. Next, having heard the learned advocate for the petitioner and considering the body of petition along with the annexures thereof, I find there is a good arguable case. So the instant criminal division is hereby admitted. Stop. Petitioner is directed to serve upon the opposite party and file an affidavit of service on the returnable date. Stop. Let the matter appear in the list in the ensuing circuit bench for the month of May 2024. Next, considering the facts and circumstances of this case, the further proceeding of GR case number 2146 of 2022 pending before the learned. Where is it pending?
Before the landed CJM, I believe.
Learned CJM Siliguri be stayed till 28th June 2024 or until further order, whichever is earlier.
Deeply obliged, my lord. With your lordship's leave, my lord.
Note 4, I'm praying for short Passover.
Pass it over.
Also, I have challenged a proceeding under section 376 and 376 and 417. Also, the allegation is that prohibition on promise to marriage and break up of the marriage was the promise. This affair was registered. The petitioner and the de facto complainant had developed a romantic relationship through the mode of virtual platform WhatsApp. On 6th of October 2018. Subsequently, they were in complete relationship for last 2.5 years, and subsequently, since they are both interpreted in their religion, therefore, ultimately with the intervention of the respective family members, marriage was held, and that was also admitted by both the parties. Subsequently, she somersaulted, and subsequently this affair has been registered. And the petitioner accordingly approached before this Honorable High Court, paying for anticipatory bail. Recording the said findings, the Honorable High Court was pleased to allow the prayer for anticipatory bail. And subsequently, the charge sheet has been submitted against the petitioner. However, in the charge sheet itself, there is no material with regard to the any elements of section 376 and all. Only the section 470, that is promise cheating. And this is an established position of law that cohabitation on the promise to marry is not per se an offense itself. So there is no material on the face of the record as well as the findings of the charge sheet itself that the proceeding can be initiated against proceed. That's why I have lost this complaint. More so, proceed the de facto complaint is found in the similar case to lodge against other accused person that I have also annexed with this with my petition. Proceed hearing at page number, kindly see at page number 52 of the 52 of my application. Having the de facto complaint is the common the de facto complaint is in her own habit, because she has initiated the similar complaint against other accused person, which has been registered at as Belguria police station number so and so and so and so. So where that is that I'm annexed here in to show that the lady is also in habit to
Okay.
proceed.
Please take down. The instant criminal revision is preferred for quashing a proceeding being sessions case number 114 within bracket 7 of 2022 arising out of Matigada police station case number 1190 of 2021 dated 16th October 2021 under section 417/376 of Indian Penal Code, currently pending before the learned additional district and session judge, first track court at Siliguri. The learned advocate for the petitioner submits that a consensual relationship was developed between the present petitioner and the opposite party number 2. Out of the said romantic relationship, they initially intend to marry each other. Stop. However, the marriage was not solemnized due to some other disputes. Accordingly, the false case was initiated against the present petitioner. He submits that the police had submitted charge sheet after conclusion of investigation, but the charge sheet also not contain any materials punishable under section 376 of IPC. Having heard the learned advocate for the petitioner, also perusing the body of the petition along with the annexures thereof, I find there are materials to entertain the present petitioner in the instant criminal division. Accordingly, the said CRRB admitted. Said no, the CRRB admitted. CRRB admitted. Stop. The petitioner is directed to serve the petition along with the annexures thereof upon the opposite party and file an affidavit of service on the returnable date. Let the matter appear in the list on the ensuing circuit bench for the month of June 2024. Stop. June is Saturday. Considering the facts and circumstances of this case, the further proceeding of sessions case number 114 within bracket 7 of 2022 pending before the learned additional district session judge first track court at Siliguri be stayed till 28th June of 2024 or until further order, whichever is earlier.
Grateful, Lordship. Grateful.
Your Honor, praying for Passover, short Passover, my senior Anindam Chana will attend virtual mode.
Pass it over.
I am for the petition, Lordship. I have assigned the impugned proceeding complaint case initiated against the initiated under section 498 and 34 of Indian Penal Code against the husband and brother-in-law and his wife and married sister-in-law, her daughter, and also the married sister-in-law and another married sister-in-law all are resident of other places. Lordship, the admittedly, the de facto complainant wife, after 1 and 3 months of their marriage, has voluntarily left away from her matrimonial home on 10th of May 2018. Subsequently, remained herself incommunicado against all the accused person. Subsequently, after influx of 5 years and 8 months, the de facto complainant come before the court below and lodge a complaint case under section 498 and 34 of Indian Penal Code. Such if the impugned proceeding I have challenged because the de facto complainant himself has admittedly left away 5 years away from her own matrimonial home and come back before the court after 5 years and 8 months and lodge a complaint, per se indicates that there is no material, this is a frivolous and afterthought proceeding simply to harass the petitioners. Even though the petitioner number 5 and petitioner number 3 are the resident of other places, being a married lady with their own respective matrimonial home. However, this case is absolutely frivolous one and afterthought, purely an afterthought. The lady himself has admitted in her own document, that is at page number 38 of my application, in an affidavit that she and her own has living separately for on 10th of May 2018. 10th of May 2018 at page number 38 of my application.
What is this?
This is an affidavit in matrimonial case.
Affidavit for matrimonial cases?
This is the DV Act.
Okay, affidavit in connection with the DV Act.
DV Act, where she has disclosed or admitted that she are living separately for since 10th of May 2018. Paragraph number 6. Marriage held on 5th of February 2017 and she is living separately since 10th of May 2018. Now the impugned proceeding has been lodged on January 28, 2013. Yes, 18 January 2013. 18 January 2013. 2023. So after influx of 5 years, this frivolous proceeding has been initiated. That too in a complaint case.
What is the status of DV Act?
There is the proceeding is going on. WS has been filed. Interim order has not yet been passed against any of the person lordship.
Okay, who are the petitioners here?
Petitioner number 1 is the brother-in-law. Petitioner number 2 is the wife of the brother-in-law. Petitioner number 3 is the daughter of the petitioner number 1 and 2. And petitioner number 4 is the husband. And petitioner number 5 is the married sister-in-law.
Okay, please take down. The instant criminal revision has been preferred under section 482 of the Code of Criminal Procedure for quashing a complaint case being CR case number 168 of 2023 initiated under section 498A/34 of IPC pending before the learned judicial magistrate second court Alipurduar. So, learned advocate for the petitioner submits that the petitioners are the husband and relatives of opposite party number 1 of opposite party stroke de facto complainant. The opposite party has lodged a petition of complaint before the learned jurisdictional magistrate stating some false and frivolous allegations. The opposite party has voluntarily left her matrimonial home in the month of May 2018 after a long period only to harass the present petitioners. The instant criminal complaint has been preferred by the opposite party. or the learned advocate peruse the body of the petition along with the annexures thereof. Considering the same, it appears to me that there are sufficient materials to entertain the instant criminal division. Accordingly, the criminal division be admitted. Stop. The petitioner is directed to serve the copy of application upon the opposite party and file an affidavit of service on the returnable date. Let the matter appear in the list in the circuit bench, in the ensuing circuit bench for the month of June 2024. Stop. Considering the facts and circumstances of this case, considering the facts and circumstances of this case, the further proceeding of CR case number 168 of 2023 pending before the learned Judicial Magistrate Second Court Alipurduar is hereby stayed till 5th day of July 2024 or until further order whichever is earlier.
Grateful, Lordship. Grateful.
Lordship, in this matter, Mr. Rajdeep Mujumdar will be appearing. He's on his way, so praying for a short.
Very well. Pass it over. Yes.
Petitioner filed an application for return of the vehicle. This application was allowed by the learned special court with the condition that he has to submit a rupees 10 lakh of bank guarantee or like such amount. Thereafter, he also filed an application for modification of this order also. This was also turned down. 10 lakh rupees is exorbitant and unreasonable. So that he can
What is the vehicle?
Minitra.
Minitra.
Minute. He's not FIR name, my lord. In the charge sheet, his name transferred, and all other accused enjoying bail, my lord. Charge sheet submitted, my lord. And parts on my lord.
Yes. 5 lakh? At least 5 lakh.
3 lakh, my lord.
No, no.
My lord, 3 lakh.
5 lakh.
4 person, my lord, 3 lakh, my lord.
No, no.
Are you giving 5 lakhs?
Yes. It would be your money. What is your guarantee is
My
there?
lord, at a one time, it's 5 lakh.
NDPS case, my lord. So-
My lord, he has no knowledge. He has no knowledge. He is not.
5 lakh is your money. It would be deposited there.
At one time, it is difficult. For this reason, I am paying for 3 lakh, my lord.
Very well, come on 4 lakh. No,
Yes, right. Yes,
no further, no
Yes.
further bargaining.
yes, yes.
Okay, please take.
But the state appearance will be noted. We
Yes.
have turned the copy on us.
The instant CRR is preferred against the order dated 29/1/2024 and order dated 9/2/2024 passed by the learned additional session judge first court Coach Bihar, come judge special court under NDPS Act, Coach Bihar, in connection with NDPS case number 14 of 2022 arising out of Mathabhanga Police Station case number 53 of 2022 dated 8th of February 2022 under section 20 within bracket B within bracket small Roman 2 within bracket C stroke 29 of the NDPS Act. Full stop. The learned advocate for the petitioner submits that the vehicle of the present petitioner was intercepted in connection with the said case, in connection with the said police case. Stop. A prayer was made on behalf of the petitioner to return the vehicle. A report was submitted by the IO who stated, which stated no objection against the said release of the vehicle. Stop. The learned special judge, VD order dated 29 January 2024, has allowed the prayer of the present petitioner to release the vehicle with a condition that the owner, that is the present petitioner, shall furnish bank guarantee stroke fixed deposit certificate of amount of rupees 10 lakh and affidavit to the effect that the vehicle would not be disposed of, and its nature and character would not be changed and would be produced before this court as and when ordered. Stop. The bank guarantee appears to me exorbitant, appears to the petitioner exorbitant, and for which he preferred an application before the learned special judge to reconsider the bank amount of bank guarantee. Thus, an prayer for modification was made. Stop. The learned special judge, by the impugn order dated 19 February 2024, has turned down the prayer. Stop. Being agreed by the said order, the present CRR has been preferred. Stop. Learned advocate for the petitioner submits that the bank guarantee of rupees 10 lakh cannot be furnished by the present petitioner as he is not so financially sound. He further submits that the petitioner is always ready to abide by other conditions, but the bank guarantee of rupees 10 lakh cannot be furnished. Stop. Learned advocate appearing on behalf of the state raised strong objection. Strong objection and submits that the vehicle was seized in connection with a NDPS case, wherein a huge quantity of narcotic drugs and psychotropic substance was seized. So he submits that the instant criminal revision cannot be entertained. Or the learned advocate peruse the impugn order dated 29 January 2024, as well as the impugn order dated 19th of February 2024. During the proceeding before the learned session judge, the report of IO has furnished, wherein IO expressed his no objection to release the said vehicle. Stop. It appears that the learned special judge has allowed the prayer to release the vehicle, but the amount of bank guarantee of rupees 10 lakh could not be submitted by the present petition. It appears that the learned special judge, when allowed a prayer, must have considered that the prayer, the order of the special judge may be carried out in its true spirit. Stop. the order cannot be carried out by the incumbent stroke the petitioner if the same is appears to be exorbitant considering the financial stringency of the present petitioner. Thus, in this case, I think it necessary to modify the order passed by the learned special judge dated 29/1/2024 that the bank guarantee would be 4 lakh instead of 10 lakh. Stop. Accordingly, the order passed by the learned special judge dated 19th February 2024 is turned down and order dated 29 January 2024 is modified. Stop. The remaining portion of the impugned order dated 29/1/2024 would be remain unaltered. Stop. The instant criminal revision is disposed of under the above observation.
Did- My 26 one of engagement I led by my senior Mr. Shabir Ahmed. দাঁড়ান একটু ফোন তো আসছে। বাসুদেব
Yes, who is appearing for the state?
Mr. Niloy Chakraborty and Arjun Chaudhary last application appeared, madam.
State is directed to produce the CD.
My lord, his area is not yet come, my lord.
CD is ready.
No, my lord. CT we have not received the CD. Depend, my lord. Monday.
Then come on Monday.
Yes, ma'am.
My lord, I have a passed over matter. And I'm joining from Calcutta. Now, my lord, I have a passed over matter, item number 8.
Seeking a Mr. Raj, please be my lords, he shall be in the court in some time.
Okay.
28 as well, my lords.
Right.
27 and 28, my lords.
Yes, what is the passover matter?
130, my lord.
Item number?
130.
Item number.
My lord, mine is 8.
Please come in. Yes, item number 4.
Lordship, in this matter, what has happened? The petitioner before your lordship was convicted by the ACGM Mekliganj on 10th of January 2019 under section 324. And thereafter, the petitioner made an appeal before the additional sessions judge Mekliganj, and the appeal was pending. As because the learned lawyer for the petitioner did not appear in the appeal, warrant of arrest was issued against him and he was taken into custody. I have made an application under section 389 before the session judge. Session judge has turned down my bail fare and the petitioner is in custody, lordship. Challenging that order, I have come before you, lordship.
So impugned order dated?
Impugned order is uh, 15th of February 2024, Lordship.
15th of February.
Lordship. Certified copy, Lordship.
How many days he is in custody now?
Lordship. Lordship, on 10th of February 2024, he was taken into custody.
February,
10th of February.
February, March, now
For-
April.
For 2 months, almost 2 months.
Yes, wish for the state.
My lord,
This is the first time.
this is the first time, my lord, let them serve the copy, my lord, because it is
Service of copy and
Yes, yes,
hearing,
yes.
it would be
No,
take
this one
time.
is not keep-
He is in custody
Yes.
for an offense punishable for 1 year.
1 year.
1 year conviction is there.
An appeal is pending.
Already 2 months in custody.
I'm copying this. Copying this. It is Xerox for-
Please take down. The instant CRR has been preferred under section 482, related to section 401 of the Code of Criminal Procedure for setting aside the order dated 4/4/2022 and 15. Yes, 4/4/2022 and 15 February 2024. Passed by the learned additional session judge Meghliganj in connection with criminal appeal number 3 of 2019, arising out of judgment and order of conviction dated 10th of January 2019 under section 324 of the IPC, passed by the learned additional chief judicial magistrate Meghliganj, thereby sentencing the present petitioner to undergo simple imprisonment for 1 year and to pay fine of rupees 1,000 in default, to suffer further imprisonment for 1 month, corresponding to GR case number 43 of 2013. Stop. The learned advocate for the petitioner submits that the present petitioner was convicted by the learned magistrate for having committed an alleged offense punishable under section 324 of IPC, and the order of sentence was passed for a term of simple imprisonment for 1 year and to pay a fine of rupees 1,000 ID to suffer SI for 1 month. Stop. The said order of conviction was challenged before the learned additional session judge Mekliganj. Stop. During the pendency of the appeal before the learned additional session judge, the present petitioner was remain in bail as interim bail as granted by the learned jurisdictional magistrate. Stop. The present petitioner could not appear before the learned additional session judge at the time of hearing of the appeal. Thus, the learned session judge, by order dated 4th of April 2022, directed the SCGM Megliganj to issue warrant of arrest by forfeiting the bond submitted earlier in favor of the present petition. Stop. The present petitioner, after having the knowledge of the said order, has approached, was apprehended. When he was apprehended,
10th of February 2024.
was stop. In connection with the number.
After having the knowledge of
Having the present petitioner taken up. The present petitioner, in the strength of the warrant of arrest, was apprehended by the police authority and was taken in custody on 10th of February 2024. Stop. One prayer was made before the learned additional session judge on 15th of February 2024 for an order of bail. Stop. The said prayer was turned down by the learned additional session judge on the ground that the present petitioner has misused the liberty. Against the said order, the present revision has been preferred. Learned advocate for the next part. Learned advocate for the present petitioner submits that the present petitioner was regularly attending the appellate court, but due to some personal reasons, he could not appear. Thus, the order for thus his bond, bail bond was forfeited. He submitted that there are sufficient grounds in the appeal, and the present petitioner is in custody for near about 2 months. So his prayer for bail may be considered. He further submits that the learned appellate court, that is additional session judge Mekliganj, without appreciating the facts and circumstances of this, without appreciating the facts and circumstances of pendency of the appeal, has passed the impugned order on 15th of February 2024. So he prayed for necessary order. Stop. Learned advocate appearing on behalf of the state raised strong objection and submits that the present petitioner has misused the liberty given by the law. So it was law. Stop. He further submits that the learned session judge had no alternative but to direct the learned SCGM to issue warrant of arrest. He prayed that he submits that the instant criminal revision has got no merit. Heard the learned advocate peruse the impugned order passed by the learned magistrate concern in respect of GR case number 43 of 2013. The learned magistrate, after considering the materials on record, has convicted the present petitioner and sentenced him to undergo simple imprisonment for a term of 1 year for the offence punishable under section 324 of IPC, and to pay a fine of rupees 1000 ID to suffer SI for 1 month. So it appears that now the present petitioner is in custody from 10th of February 2024. Stop. The learned session judge has not considered the prayer of bail on the ground that he misused the liberty. However, it appears that as the appeal is pending and as the petitioner is in custody near about 2 months, I think it necessary that the present appellant, present petitioner may be enlarged on bail on some strict condition. Stop. Accordingly, the order passed by the learned session judge on 15th of February 2024, as well as 4th of April 2022 are hereby coerced. Stop. The present petitioner, namely Dilip Bosak.
Dilip Kumar Bosak. Dilip Bosak alias Dilip Kumar Bosak.
Dilip Bosak alias Dilip Kumar Bosak. Be released on bail of rupees 4000 with 2 registered security, subject to satisfaction of the learned SCJM Meghliganj, with further condition that he must appear before the learned additional session judge on each and every date of hearing of the appeal. He must not leave the he must not leave the jurisdiction of the learned additional session judge Meghliganj without permission. Stop. The petitioner is further directed to appear before the learned SCJM Meghliganj and pray for regular bail within 2 weeks from this date. Accordingly, the instant payment.
He is already in custody, so.
Okay. I understand. Last. No, correct. Another observation, the CRR is disposed of.
Deeply ordered.
Yes.
My lord, item number 8 is my application. My lord, I do not know whether I am audible. My lord, I cannot hear you, lord. My lord, I cannot hear you, lord.
Yes, what is your matter?
My lord, learned senior will proceed.
My lord, I got detached from the link. Yes, my lord, so the code is visible, but my lord, I cannot hear your lordship. My lord, my application for release of the vehicle, which was seized his connection with the NDPS case, has been turned down by the learned by the learned trial court. My lord, kindly sees the reasoning given there. And I have, my lord, the order dated 19th February 2024. Kindly sees the reasoning. It is the second last paragraph. But the court is of the view that find once the vehicle is released, so there is every possibility that this petitioner is accused, he may use the vehicle again for the same purpose. Though, my lord, there is no observation as to whether this petitioner is having any criminal antecedent.
Okay, okay.
And moreover, my lord, the power of confiscation under section 60, my lord, has to be done after the trial is concluded. During this period, if the vehicle is lying there and ultimately it will get destroyed with a flux of time, then what is the use? And ultimately, the confiscation proceeding at the end of the trial cannot be done. Therefore, the interim custody should be given.
Ah,
My lord, I have to serve and come back. My lord, kindly give us short returnable day of next week. Let me serve and come back. Because today is the first day. It is under the heading motion.
that is in connection with NDPS case number 66 of 2022 arising out of New Jalpaiguri police station case number 538 of 2022 dated 23/5/2022 under section 21 within bracket capital P capital C stroke 22 bracket capital C stroke 25 stroke 28 stroke 29 of NDPS Act, whereby the prayer of the present petitioner for return or release the seized vehicle has been turned down. Stop. Stop. Peruse the body of the petition along with the annexures thereof, as well as the impugned order passed by the learned magistrate, learned special judge. Stop. Having heard the learned advocate, it appears to me that the matter can be effectively heard in presence of the matter can only be effectively heard in presence of the state. Stop. Accordingly, the petitioner is directed to serve the petition along with the annexures thereof to the opposite party and file an affidavit of service on the returnable date. Let the matter appear in the next available circuit under the heading of contested application.
No, my lord, let it be under the heading listed motion. If you retain his position, it will be hard. I know, my lord, contested applications are taken up regularly there, but if he retains his position under the same heading, it can be hard. Subject to your lordship's convenience and
Under the same heading.
I'm grateful.
This only three matters are left in now. And all three matters, Mr. Rajdeep Majumdar will be appearing. He is on his way actually. The flight got delayed. Can this matter be taken up in a fixed time if your lordship permits?
The next week?
He's on his way already. Has requested me to apprise you. I might be at 12:30 or something.
Okay. Let it be pass over for this hour. Okay. Call next matter.
On all three matters, like remaining three matters, 10, 27 and 28. Oh, 31 is.
Lordship, I am for the petitioner. Lordship, it is an application for expeditious disposal of probate case.
Who are you?
Lordship, I am the petitioner.
Who are you before the learned additional district judge?
Lordship, I am the petitioner, applicant.
Applicant.
Lordship, in this case, the petitioner is seeking a grant of probation case, probation of a will, which was executed by his late father, who died on 16/11/2021. And the bill was executed on 30/9/2025.
Being contentious, it was proceeded to the learned additional district judge under the heading
Yes,
of OA. So what is the now status? of the-
Lordship, now it is pending before the learned additional and district judge, first court at Siliguri.
Yes, what is the status of that case? Present status. What is the stage?
Lordship, may I be permitted to tell you the dates wise? What is the incident, like what happened in the case?
Yes, submit.
Lordship, at first, the case was started in 2021. Then on April 2022, opposite party appeared and made a written statement. There they were telling that it was a false and fabricated will. Was then on 1/3/2023, the case was transferred from Court of Learned District Judge to Additional District and Session Judge, First Court. Then Lordship, on 2/3/2023, the matter was again taken up and it was fixed for 18/4/2023. On 18/4/2023, the matter was again fixed and it was said that
Why it was fixed? What is the
for
purpose?
framing of issues.
For framing of issue.
Yes, Lordship. Then, but it couldn't be framed as PO was transferred. Then on 19/7/2023 and 21/8/2023, this framing of issue couldn't happen because PO has been transferred. And then on 15/9/2023, court was pleased to direct paper publication. Then Lordship, on 18/11/2023, the matter appeared and fixed for 3/2/2024 for Saristadar report. And then 20/12/2023 for approval of the draft of paper publication as per the plaintiff. And then on 20/12/2023, learned court directed the petitioner to file a fresh draft copy of paper publication. On Lordship, on 22/12/2023, the paper publication was approved. And on 3/2/2024, PO was again on the leave. That's why nothing substantial could happen at that day. And on 22/2/24, paper publication was done. Lordship, please kindly turn to page number 26. Paper publication has been done there. Lordship. And again, then date was given 24/6/24. Procrastination is happening, Lordship.
You have prepared an application under Order 11, Rule 12.
Yes, Lordship.
So that has to be disposed of. You have prepared the application, you have made the paper publication. All your procedure is going on.
Lordship, they are taking lot of time. The below court is taking 2 to 3 months. He is giving that type of date. Lordship,
No,
please.
no, that is not the procedure. You have to exhaust the proceeding. Otherwise, how can I press hard upon the learned additional session judge to dispose of the matter? The procedure has to be exhausted. Your service was not affected. That's why you are directed to serve through paper publication. The paper publication was done at your behest. Thereafter, you prepared an application for discovery. These are there. The
Lordship.
discovery has to be made. Thereafter, you have to prepare one application. Are you conducting lawyer before the learned court below? Then you don't know what is going on there.
Lordship, please.
What you want? The matter cannot be disposed of within 6 months because it appears that the petitioner has to take some steps.
So,
Only at the stage of discovery is there. The trial stage has not been initiated here. How you prepare this application? You exhaust the procedure. Thereafter, if the delay of trial is there, thereafter the order can be passed for expeditious disposal of the trial. The procedure has not been exhausted. These are the separate matter regarding the wills. Challenge of wills are there. Why you prepared the application under order 11 rule 12 regarding discovery? Do you know? After discovery, one amendment application has to be filed by the plaintiff petitioner. Thereafter, additional written statement would be there. Thereafter, again issue would be framed. These are the stage that has to be exhausted. That cannot be exhausted in a one day.
Lordship, please kindly direct the court to do expeditious proceeding at
How?
least.
How? Your procedure is there. You have to exhaust. Otherwise, you undertake that I will take no steps regarding the procedure. The
Lordship,
trial can be.
petitioner is taking all the steps. The
No,
respondent isn't
no,
taking.
you are not following the procedure. If you undertake that I would take no further steps, then I can direct the additional decision to fix the matter to PH, peremptory hearing. Then you would be suffer much.
Lordship, the thing is that the petitioner is having lot of shares and immovable properties and properties that are being stuck. He's not able to release that. That is the reason. It was instituted in 2021 and now it is 2024, Lordship. That's why I'm praying, Lordship.
That is not for the purpose of the court or any procedure like that. The procedure, settled procedure is there. You have to exhaust. You prepared an application for probate that was being contentious by your relative and it was transferred to the district judge's court and it come to the OS, other suit, under the heading of other suit.
In this petition, I'm only talking about probate case.
This is the probate case. Other suit is the probate case. After being contentious.
Sure.
What you want? You have to exhaust the procedure. You are not taking proper steps. Why you prefer the application under order 11 rule 12 regarding the discovery? Your application is there pending. The application has to be heard in presence of the other party. They have to be given liberty to file written objection. Thereafter, you have to prefer one application for amendment, additional written statement, additional issue, everything would be there. It requires further at least 1 year to exhaust all the proceeding. Thereafter, the trial would be start in this case. These are the separate type of case. It cannot be exhausted like a criminal case. You hear the out and dispose of the matter. If you want, I can pass a specific order that initiate the peremptory hearing and dispose of the matter.
Lordship.
Then you will be suffered a lot. And these sufferings cannot be cured by the Supreme Court also.
Lordship, then kindly keep this matter tomorrow.
Why?
I will prepare more and then I can,
No,
I
no.
guess, I can
I
satisfy you,
understand.
Lordship.
I understand. You come later. You come later. I am giving you liberty to prefer the application on later stage. Please take down. Madam, these are the separate type of cases which has to be exhausted properly, otherwise you would be
Lordship,
suffered.
I am getting your point, Lordship.
You would be suffered. Otherwise, the point you have taken regarding the discovery of the appeal, discovery of the will, and the other will the opposite party has deposited. These are the issues there. You do not know what is going on there. That's why an application for under order 11 to rule 12 was
Lordship, at least
filed.
the proceeding,
Proceeding is taken at your behest, sir.
it is taking in a snail days position.
As because you have taken the steps one after another.
Lordship, the learned court is taking a lot of time to do that. They are taking time again and again.
No, I cannot direct the learned court to take the steps day after day, day after day. It is not possible for you. It is not possible for you to take the steps day after day. The paper publication is required. Everything is required.
Already paper publication has been already done, Lordship.
Then why you have preferred the application under order 11 rule 12? Your petition is pending there. Very well, please take down. The instance CO is preferred for expeditious disposal of a of OC bracket probate case number 3 of 2023 pending before the learned additional district judge, first court Siliguri, arising out of misjudicial case number 60 of 2021. Stop. Learned advocate for the petitioner submits that the probate proceeding is initiated in the year 2021 till today.
There is no framing of issue.
Till today, the issues
Has not been framed.
till today, the issues has not been framed. Stop. Learned advocate petitioner further submits that the petitioner is suffering
Delay.
immense due to the delay of the instant proceeding. Had the learned advocate peruse the certified copy of the impugned orders passed by the learned additional district judge in the above proceeding, it appears that the initially the date was fixed for framing of issues, but after paper publication by the plaintiff has filed one application under order 11 rule 12 read with section 151 of the code of civil procedure. Stop. It appears that the procedure of the said suit of peculiar nature has not been exhausted yet. Accordingly, I find no justification to entertain the instant CO. However, the additional district judge is directed to frame the issue as early as possible, more preferably within June 2024. Stop. The CO is disposed of on the evidence.
Grateful, Lordship.
According to the law, 24, according to the law. CO. Next.
Yeah, but. Ajay.
Great. Appeal hearing.
Okay, that's very good. The NN and I have for the insurance company. Police benefit is.
Clement is the appellant.
This matter, I am appealing for the applicant, your lordship.
Yes.
With the short points, your lordship, the petitioner's right hand was amputated due to the injury. Now, he was treated, your lordship, and thereafter, the medical report certified 80% disability. The learned tribunal granted the compensation. Your lordship, the claim was that he was a motor mechanic. He used to earn rupees 9,000 per month, but the learned tribunal assessed rupees 6,000 per month. Next, your lordship, the disability was taken at 80%. Now, since his right hand was amputated, the pain and suffering was given at rupees 2 lakhs.
Okay.
But also the future prospect, that was not granted. He was 22 years old. So, in view of pronunciation, your lordship, 40% of to have been assessed. And your lordship, the multiplier was taken 17 as per second schedule of the Motor Vehicles Act, but as per Salah Verma, it should be 18.
Yes.
So these are the two main points. But other point, your lordship, is to consider, your lordship, that a motor mechanic who lost his right hand, whatever his the occupation, your lordship, his occupational loss is 100%. That is my another point. So instead of 80%, the occupational loss should be 100%, treated as 100%. Pain and suffering, this amount is okay, your lordship.
Is there any evidence that he was a motor mechanic?
Self-evidence, your lordship.
Only self-evidence.
Self-evidence. But on that part, there is no cross-examination. Self-evidence. He was treated at Eastern India Gandhi Regional Institute of Health Medical Science. So discharge certificate is 44. Page 44. With regard income, I don't have any objection, your lordship. 6,000, your lordship, that's. But the future prospect and the multiplier, and if it is possible, your lordship, to consider, since there is self-evidence, if it could be assessed as occupational loss as at 100%. The dissolvent certificate is at page 46. It is permanent.
Multiplier 18.
Multiplier would be 18. Income 6,000. Future prospect 40%, your lordship. So 2,400. Multiplier 18. And pain and suffering 2 lakhs granted, your lordship. And only thing, your lordship, whether it would be 80% or 100%, because on the discharge certificate it is stated permanent dissolvement.
Yes, what is it?
The date of accident is 2015. The tribunal granted 6,000 at that on that, and the date of award is 2018. There is no future perspective there. But that also, and at that time also, the tribunal considers 6,000 per month. So highest, and without anything, we have paid interest 6%, everything. 2 lakhs for pain and suffering, extreme. Just my point is that just future perspectives. Now,
And what about the functional disability regarding 100%?
100%. My lord, we have already get 2 lakh for pain and suffering and for everything. Consider 6,000. All the courts are considering 4,000, 3,000 at that time in the year 2018. Highest level. The award was passed in the year 2018.
There is no appeal on behalf of the insurance company.
I have just.
And your lordship, it depends, your lordship, the facts and facts, your lordship. There is no hard and fast rule that in view of the year 2014, 4,000 or 2015, 5,000, your lordship.
Very well.
London Tribunal saw the person
Yes.
personally. So he assessed that. London Tribunal assessed the income.
Okay, please take down. The instant appeal is preferred against the judgment and award dated.
Your lordship, another point, your lordship, the general, no, your lordship, it's all right, your lordship. Sorry.
The instant appeal is preferred against the judgment and award dated 26th June 2018, passed by the learned judge, Motor Accident Claim Tribunal, Jalpaiguri, in MAC case number 93 of 2016. Stop. The brief fact of the case is that the present appellant claimant on 3rd of June 2015 at about 5:30 hours when was going towards Silchar to Guwahati on a bus bearing registration number AS01 AC-6135, which was driven in a rash and negligent manner. The bus met an accident. As a result, the present claimant appellant sustained injury, sustained severe injury at his right arm. Thereafter, the claimant was immediately shifted to the hospital, and due to the and during the treatment, his right hand was amputated. Right hand has been amputated. Stop. The disability certificate issued by the government hospital stated his permanent disability to be 80%. Stop. Next paragraph. The claimant preferred an application under section 166 of MV Act before the learned tribunal for getting compensation. Stop. The insurance company contested the claim case by filing written statement. Stop. After hearing the parties and after receiving the evidences, the insurance company has awarded a sum of rupees 11,89,200 together 6% interest in favor of the claimant. Stop. Being agreed by and dissatisfied with the said award, the present appeal has been preferred for enhancement of the award. Stop. The learned advocate for the appellant submits that the learned tribunal has failed to appreciate the facts of this case and at the time of assessing the compensation has not awarded the future prospects as as directed by the Honorable Apex Court in Pranay Sethi. Stop. He further argued that the multiplier adopted by the learned tribunal is 17, but by virtue of decision of Honorable Apex Court in Sarla Verma, followed by Pranay Sethi, I think Pranay Sethi is option, National Institute Complement versus Pranay Sethi. Limited versus Pranay Sethi. Sethi, the applicable multiplier would be 18. Stop. Learned advocate for the appellant further argued that the present petitioner was a motor mechanic and due to the accident, his right hand was amputated. Stop. Actually, due to such accident, the present appellant has lost his job. So in this case, the functional disability would be 100%. Stop. Next paragraph, the learned advocate appearing on behalf of the insurance company raised strong objection and submits that the learned tribunal has considered the entire case very leniently. Though the income or occupation of the claimant was not proved, but the learned tribunal has assessed the annual income of the claimant to be annual monthly income of the claimant to be 6,000. Stop. The 6,000. The notional income of rupees 6,000 as assessed by the learned tribunal is on higher side. So in this case, the learned tribunal has rightfully denied to award the further amount under the head of future prospects. However, he admitted that the multiplier applied in this case, applied by the learned tribunal is erroneous in view of the decision of the Honorable Apex Court in Pranay Sethi. Stop. The learned advocate appearing on behalf of the insurance company submits that the claimant sustained injury during the accident in his right hand. The right hand of the injured was amputated during treatment. Stop. The injured appeared before the government medical college, wherein his disability was assessed to be 80%. Stop. The only a limb of the deceased was amputated. So the deceased, sorry, this is not limb of the injured. This is only one limb of the injured was amputated. The other portion of the body remained intact. So in this case, the functional disability cannot be 100%. Heard the learned advocate, the only heard the learned advocates. Full stop. The future prospects was considered by the Honorable Apex Court in constitutional bench in Pranay Sethi. Stop. The Honorable Apex Court has fixed the particular percentage in respect of the age of the victim in a case under section 166 of MD Act. Stop. The several decision of Honorable Apex Court has followed the observation of Honorable Apex Court in Pranay Sethi in awarding the future prospects. So in this case, the learned tribunal has committed error for not awarding the future prospects. Stop. The age of the claimant is within the is below the 40 years and he was not in a permanent job. So the compensation must compensation towards the future prospects would be 40% to his established income. Stop. Next one. The multiplier of this case would be 18 in virtue of the decision of Honorable Apex Court in Sarla. Stop. Next one. In considering the functional disability of the present appellant, the opinion and decision of the Honorable Apex Court in Rajkumar versus Ajay Kumar is relevant. Stop. The Honorable Apex Court in Rajkumar versus Ajay Kumar has held that the disability calculated by the government hospital and doctors cannot be taken to be the functional disability considering the particular occupation of any claimant. Stop. In this case, the occupation of the present petitioner was stated to be the motor mechanic. Stop. It has been argued that being the motor mechanic, he lost his job due to the amputation of his right hand. Stop. However, it appears to me that the 80% permanent disability is sufficient to taken to be the functional disability of this case. I find no justification to assess the functional disability of this case to be 100%. More preferably, the present claimant has only lost his right hand. His left hand is intact. So in this case, permanent disability has been correctly calculated by the Learned Tribunal to be 80%. Considering the same, I find nothing to enhance the permanent disability in this case. Considering the whole aspect, the award passed by the Learned Tribunal requires modification. 40% future prospects.
So I have prepared one calculation, Your Lordship, after taking 80%, Your Lordship. Your Lordship, medical expenditure was granted 10,000 that I have.
So after calculation, the award comes to rupees 16 lakh 61,520. Stop. The claimant appellant has already received an amount of rupees 11 lakh 89,200. Stop. The balance award comes to rupees 4 lakh 72,320. Stop. The insurance company is directed to pay the balance awarded sum together with 6% interest per annum from the date of filing of the claim application, that is from
Your Lordship, claim application was filed. But March 2016.
3rd March 2016 till its actual payment. Stop. The insurance company is further directed to pay the award through the office of the Learned Tribunal. To the office of the Learned Tribunal by issuing an account pay checks in the name of the claimant within 6 weeks. Stop. The payment of compensation is subject to the ascertainment of payment of deficit court fee. Stop. The Learned Tribunal shall act upon the certified copy of this order to receive the deficit court fee. LCR be returned at once. FMA connected application disposed of.
Article 42, Your Lordship, I am appearing. Mr. Raichudhary is appearing on behalf of the
Insurance company only use short point, your lordship, 163A. Now, after the judgment of Urmila Halder, your lordship, the fixed amount is fixed 5 lakhs with interest. That is the only point, your lordship.
Do you have the copy of Urmila Haldar now?
Your lordship.
Because I am now crippled.
My lord, I have some problem. Yeah. Seriously, one order was made, that order, name of the, I forget what the company was. Not me, but I put my power criteria.
আপনার নাম চলে যাবে, কোনো অসুবিধা হবে না। আপনার
In the previous order.
Mr.
By
Name
mistake,
of
your lordship-
Mr. Chakraborty is there.
Your lordship, since Mr. Chakraborty was appearing, your lordship, in other matters, somehow your lordship, the name was recorded.
However, no issue. No issue. I'll note down your name. Give me your paper. Give me
Lordship, is it
Urmila
okay?
Haldar.
Of Urmila Halder. I'm giving a copy to my learned friend, your lordship.
Yes. Four lakh 18,000 was awarded.
Was awarded, that should be 5 lakhs plus interest, your lordship, from the date of the filing till. So interest, your lordship, on the balance amount.
Is there any interest in this award?
Your lordship, interest
Was not given. I
was not there. So anyway, default interest was granted, your lordship. Default interest.
4
Default,
lakh
so
15,000.
that should be mandatory, your lordship. 6% from the date of the filing till payment, your lordship. Your lordship, on 4 lakhs, 15,000, 6% from date of the filing till payment before the tribunal already paid. And balance 85,000, your lordship, that should be.
From the date of filing to the till payment.
Till payment. So there are two parts, your lordship.
I understand that. Please take down. Yes. You know the rule that it has already been passed. The law has been stated. Has been settled, and the interest portion has been also been stated by the Honorable Apex Court in this matter.
6%.
Yes, 6%.
Actually, the Planet Advocate giving me an estimate that was in the previous that was like this.
Law has been changed now.
Now it's what?
Now the law is changed.
Yes.
Very well.
The instant appeal is preferred against the judgment and award dated 27th March 2018, passed by the learned judge, Motor Accident Claim Tribunal, Jalpaiguri, in MAC case number 164 of 2016. Stop. The brief fact of the case is that the present appellants, being the claimants, filed an application before the learned tribunal under section 163 of MB Act for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle duly insured under the policy of the insurance company. Stop. The claim case was contested by the insurance company by filing a written statement. Stop. After hearing the parties and after receiving the evidences, the learned tribunal has awarded a sum of rupees 4,15,000 and directed the insurance company to pay the compensation. Stop. The insurance company has already complied with the order. Stop. Being aggrieved by and dissatisfied with the said award, the claimants have referred the instant appeal for enhancement on the award. Stop. Learned advocate, appearing on behalf of the claimant, submits that the law of the land has been changed by virtue of the decision of Honorable Apex Court in New India Insurance Company Limited versus Urmila Haldar. It has been assessed by the Honorable Apex Court in the case of Urmila Haldar that the fixed compensation amounting to rupees 5 lakh in a case of in a case in a fatal accident case where death has been caused would be 5 lakh. Would be 5 lakh. Stop. The same view may be applied in this case. So the necessary order may be passed. Stop. Learned advocate appearing on behalf of the insurance company submits that the instant case was initiated, instant appeal was initiated on the against the award passed by the learned tribunal. The insurance company has already complied with the order. Thus, after receiving the award, the claimants are precluded to prefer the appeal. Stop. Or the learned advocate peruse the observation of the Honorable Apex Court in Urmila Haldar. Stop. The division bench of the Honorable High Court by its judgment dated 9th August 2018 has awarded a compensation to the tune of rupees 5 lakh. It has been specifically dealt with by the division bench of this court that the Gazette notification dated 22nd May 2018 passed in connection with section 163 of MV Act is to be applicable in all pending cases prior to the notification. Stop. The said view was of the division bench was challenged before the Honorable Apex Court. The Honorable Apex Court has decided the issue on February 8, 2024 and affirmed the order passed by the Honorable Division Bench of this court. It has been stopped. And the Honorable Apex Court has further guided that the award passed in a case where the death has been caused has to be fixed to be 5 lakh and it must have carried some interest. Stop. By virtue of decision of Honorable Apex Court in Urmila Haldar, it appears to me that the award passed by the learned tribunal requires modification. Stop. In this case, the insurance company has already complied the award of rupees 4,15,000. Stop. Thus, the rest award comes to rupees 85,000. Stop. The insurance company is directed to pay the compensation of rupees 85,000 together with 6% interest per annum from the date of filing of the claim application. Until its payment, till its actual payment, and also further directed to pay the interest of rupees 6% per annum from the date of filing of the claim application to the date of payment of amount of rupees 4,15,000. Stop. The insurance company is further directed to comply.
Date of payment is 30th April 2018.
Yes, you calculate it and pay it. Then we directed to comply with this order within 6 weeks from the date of this order through the office of the learned tribunal according to the direction of the learned tribunal. Stop. The payment of compensation is subject to the settlement of payment of the deposit court fees. The learned tribunal shall act upon a certified copy of this order to receive the deposit court fee.
Deeply obliged, your lordship. Forty-three, your lordship, I am appealing for the appellant, your lordship. Mr. Bormon is appearing on behalf of the respondent insurance company. Lordship, the short points involved in this matter, your lordship, that the future prospect that ought to have been assessed, and income which was considered by the learned tribunal, a lump sum amount, your lordship, the learned tribunal assessed on the basis of the income tax return filed for the 5 years. But your lordship, the law is now settled in two judgments, in Sasikala and another judgment. In Sasikala, your lordship, the Supreme Court says that the last income tax return that should be taken into consideration. And the other judgment, Supreme Court says that which is the better amount, which is the best amount, that should be considered. So even in view, your lordship, the two judgments, your lordship, the income tax return, your lordship, of the last year, that amount, your lordship, that should be considered. It is my submission. I place the judgment, your lordship.
Now, what was the income in the last assessment? What is the date of accident?
Date of accident, your lordship, 2014. 2014.
Last income tax return for the assessment year 2014-15.
2014. Your lordship, it is mentioned in the judgment itself, your lordship. Your lordship, can you come to the judgment? Page 26.
4,97,000.
Your lordship, 4,97,000, that is all wrong, your lordship. That should be added with 1 lakh. 5,97,000. 1 lakh was deducted as LIC payment. Now, as per the LIC, your lordship, 1 lakh will be deducted.
Where is the
Your lordship,
ITR?
the LIC certificate, your lordship.
Where is the ITR? Where is the ITR for the year 2015?
Your lordship, I received that, your lordship.
Refer me the page.
Page 133 is 2012-13. And page 155 is 2013-14. And page 180, your lordship. Page 180. Two thousand 14-15. Lordship, the gross total income 5,97,000. Deduction under chapter 6A 1 lakh. The
One-
chapter
Page 180.
180. One eight zero.
Yes.
So my submission should be income that should be considered 5,97,000, Your Lordship. Less income tax, Your Lordship. The income tax, Your Lordship. Income tax paid, Your Lordship, 28,564 on that year.
What is the occupation?
Your Lordship, he has several business, Your Lordship, business of hotel, trading and other, Your Lordship. He's a reputed businessman, Your Lordship.
Yes. Income and another?
Income, Your Lordship, and the deduction is rightly now. The multiplier that should be lowered down at multiplier 16, it should be. It's 35. So like the 35 multiplied 35 16 was granted in this case, Your Lordship. So that should be remain. And general damage, Your Lordship, that should be 70,000 plus, Your Lordship, 14,000, 20% increase. The Punaseti judgment in 2017. So 2020, 10% and 2020, 23, 10%. So 14,000 should be added with 70,000.
No.
And future profit should be 40,000 since he was, the deceased was 35 years.
Multiplier?
Multiply 16.
Multiplier
35, age 35,
correctly adapted.
31 to 35, 16, according to Salavarma.
Multiplier 16.
And general damage that should be 70,000 with the addition of 14,000, actually 20%. since 7 years have been passed from the delivery of said judgment.
Judgment was passed in the year 2017.
17, your lordship. Yeah, in this matter,
Yes,
your lordship 17.
70.
If
So
appeal was filed in
70,000.
2019, your lordship, and there
At best, it can be 77,000.
17, your lordship, 77,000, 10%.
And future prospects would be 40%.
40%, your lordship. Age 35. So up to 40, your lordship, 40%.
These are the grounds. Only these are the grounds.
Your lordship, only wife. Deduction 1/3.
Deduction 1/3.
1/3.
Yes. Who are the claimants?
Your lordship,
Only wife? No.
only wife. Only wife.
No. Wife and mother is there.
That your lordship.
Wife and mother is there.
Wife and mother, your lordship. No issue.
Okay. Yes.
Before going into the merits of the appeal, so far the points as agitated by the petitioner that so far the income is concerned. From the judgment, it is crystal clear that there is a specific reason why the learned tribunal or rather the court below has held that the average income should be considered. At page 4 of running page of 4 of the judgment, your lordship.
Yes.
And now let us consider the income of the victim. Petitioners to prove the income has filed the return assessment year 2011, 12, 11, 12, 12, 13, 13, 14, 14, 15. For the year 10, 11, it is 2,62,100. 11, 12, 2,57,000. 12, 13, it is 2,65,000. 13, 14, 4,81,000, and 14, 15, it was 4,97,320. And the tribunal, after giving his logic, came to a logical conclusion that income should be 3,000. Since the disease was a businessman and considering the
3 lakh.
3 lakhs
Yes.
annual income, considering the flow of income. Like, your lordship knows better well than the return. It is admittedly filed not by a salaried person or having a fixed income. It is a return, self-assessed return filed by an individual according to his own whims. They are, as per their version, he was a big businessman having several business, although nothing has been mentioned in the evidence or in the claim petition that what exactly was his business. In from the record, it will appear that nothing has been filed in support of his business, save and except the activities which are that too self-assessed according to own whims. But in support there nothing has been proved, and accordingly our submission is that the Ranjit Tribunal has rightly considered the average on the basis of several earlier decisions that when there is returns, income tax returns of 2-3 years filed by the petitioners, maybe self-assessed or salaried person, it should be considered as average. So, right, so far income is concerned, our submission is that the Ranjit Tribunal has rightly taken the point 3 lakhs to be the annual income of the deceased and has calculated the amount of consumption accordingly.
One thing also, income tax officer was examined. And all the documents have been exhibited.
Yes. Lost. So far, if we go to the claim petition, it is at page 20. At page 1. Lots of at page 1 of the claim petition, if we go through the column number 4, which I have already stated that nothing has been stated so far the business is claiming such a huge amount, but nothing has been stated or corroborated by any oral or documentary evidence. Secondly, in column number 12, there's claim is 95 lakh 75,000, but there is no claim because this is the date of loss was of 2014. At that time, that promissory was not there, and accordingly, there is no claim. No amendment has been sought for by the petitioner, inserting the prayer for future prospect and other reliefs as per the Act. So, since the date of loss is of 2014, as per the statute, as per the Motor Vehicles Act, your lordship was available that as per the schedule, the judgment speaks correctly about the funeral expense of rupees 2,000. That has been correctly held. Because this is neither their claim by way of any amendment, nothing has been brought in the claim petition claiming such relief. So such relief for future purpose is not there in the claim of the petitioner lordship. So our submission is that the tribunal has rightly allowed only 2,000 for as funeral expense. And so far future prospect is concerned, that is also since same submission that it is a case of 2014. That nothing has been paid for the on the head of future loss of future prospect. In this regard, I like to refer to citation of our Honorable Apex Court report in 2017 ACJ page 697, where it has been held. Fatal accident principal assessment, future prospect, claimant seeking enhancement of compensation on the ground that nothing has been awarded on the head of future prospect. Our Honorable Advocate has held that if nothing has been awarded under one head, though it should have been so awarded, but eventually the figure of the compensation, if appears to be just and reasonable, whether it be proper to interfere in such, SLP held no overall award compensation just, and our Honorable Apex Court has refused. In another citation in 2017 also by our parent High Court in 2017 ACJ page 986, it was also held that so for principal quantum, fatal accident, principal assessment, future prospect, whether any amount to be added in assessment of income, the disease for future prospect held no unless any special circumstances is pleaded and evidence is laid before the tribunal to that refer as nothing in the scheme or model to that evidence. At page 32, it is not legible. Relevant correct paragraph. It is marked. So far income is concerned, tribunal so far in disposing was rightly held the assess the income as 3 lakhs per annum, and the since nothing has been paid or claimed or adduced so far future periods, it has been refused, and since it is the date of loss is 2014, so the loss of funeral expense has been done as per the schedule as provided in the MB Act. And so far the merits of the case, lordship, the OPW, the opposite party, being the respondent number to appear in this case and has filed their written.
Lordship, my learned friend can't place that, Lordship, since there is no appeal.
Lordship, this is continuation of the suit. Appeal, we can also raise this point.
What point?
The point of involvement, we have also adduced evidence in this case. Lordship, if you, Lordship peruses the FIR at page
No, what ground?
Involvement of the vehicle also.
Then you have to prefer an appeal.
Lordship, you know,
No, the law has been specifically settled by the division bench.
Lordship,
You cannot go beyond the law.
this came from principle and they have not paid.
And these principles
Lordship,
of future prospects
Lordship,
is come under the purview of the division of the Constitution Bench of Pronacity. That in several high courts and Supreme Courts is awarding the future prospects in huge amount and not awarding the future prospects. That's why the all matter come into the purview of the Pronacity in a constitutional bench.
Our submission
These are the 17 judgments of January.
Of Supreme Court, Lordship.
January, and in September the constitutional bench sat and told that on all cases the future prospects has to be considered. This is the view.
Lordship, our submission is
Okay.
already
Okay.
Lordship has expressed over the future, but our so far income is concerned, we are very much
Okay.
pressing hard on our submission that since nothing has been brought, because it's not a single sheet of paper has come before the trial court.
Okay, very
The support of his income.
Give me the judgment. Give me the judgment.
Lordship, this is the judgment. Lordship, is the judgment of Shashikala and others
Shashikala.
such as Ganga, Lordship, reported in 2015, volume 9, Supreme Court cases 150. This is relevant page, Your Lordship, that I've marked by, it is noted by pencil, Your Lordship, in my copy, Your Lordship. Kindly ignore that, Your Lordship.
Very
No, Your Lordship. Lordship, kindly first come to para 16. May I read, Your Lordship? Insofar as appropriate multiplier, the date of birth, you see, this is multiplier, Your Lordship. You see, first para 8, Your Lordship, para 8. Para 8. This is was doing transport business of supplying newspaper from head office to other destination as per agreement entered into the group of newspapers and himself. It is also not in dispute that this was an income tax assessee and he was filed income tax return for the assessment year 2005-6 and 2006-7. The claimant had filed income tax return of the deceased for assessment year 2005-6 and 2006-7 with gross total income 1,08,713 and 2,02,911 respectively. Including the income from the house property, the total income of both the years comes to 3,11,624 and the High Court has taken the average of it, which comes to 1,55,812. The High Court deducted 10% of the said amount towards income tax and taken the balance amount of 1,40,233,231. The High Court had further deducted 2,400 towards professional tax and income from the house property, so on and such. So this is the first, you see, the average. Then you will kindly come to para 9. The deceased was 45 years and was doing transport business. Though the claimant had filed income tax return for the assessment years 2005-6 and 6-7 as per income tax return for the year 2006-7, the income of the assessee 2,02,911. The tribunal did not take the income of the deceased for the assessment year 2006-7 on the ground. The only Xerox copy was filed and the claimant have failed to examine the income tax authority to prove the same. Instead of taking the income of the deceased as per assessment year 2006-7, the High Court has chosen to calculate the average of the income of two assessment year 2005-6 and 2006-7. Considering the age of the deceased and the nature of the business he was doing, In my considered view, the High Court was not justified in so taking the average income of the two assessment years. The deceased was 45 years and doing business. Admittedly, he was also owing agricultural lands, even though agricultural income was not shown in the income tax return. It emerged from the evidence that the deceased was also doing agricultural work. Now, Your Lordship, next, Your Lordship, paragraph 15. Without adhering to the issue whether addition are to the made to the trust future prospect or not, it is obligatory on the part of the court to avoid just compensation considering the age of the deceased. Now, Your Lordship, this is vital. Considering the age of the deceased and the nature of business he was doing, in my view, the income of the deceased as stated in the income tax return for the year 2006 7, that is 2,02,911 may be taken as the income of the deceased. That is the last judgment. This is the one judgment. And the other judgment, Your Lordship. One minute, Your Lordship, I'm giving. This is judgment report in 2020 volume 4 Supreme Court cases.
Mala Vista.
Mala Vista. To see para 6. In appeal, the High Court concluded that on an analysis of the income tax return filed by the deceased for financial years 95-96 to 2001, the income declared by financial year 1997-98 was the highest and must be taken as the annual income of the deceased. Hence, 2,02,211 was determined to be annual income of the deceased. Rupees 40,000. Now, Your Lordship, this is first. Then you see para 10.
Yes.
The first portion you kindly left. The last para, the tax return indicates annual income of rupees 2,11,131 in the relevant assessment year. Mr. Jayant Raj, learned senior counsel appearing on behalf of the appellant, contended that the other documents which were marked reflected the income of the deceased. We are in agreement with the High Court that the determination must proceed on the basis of the income tax return where available. The income tax return is a statutory document on which reliance may be placed to determine the annual income of the deceased. To the benefit of the appellant, the High Court has proceeded on the basis of the income tax return for the assessment year 2097-98 and not 99-2000 and 2000-2001. So, beneficial part, Your Lordship.
Yes.
So, whichever is the highest, Your Lordship. Here, Your Lordship, last return, that is the highest tax rate and tax shown, income shown.
Okay.
And also these two judgments, Your Lordship, were followed by Justice Patnaik in one case of my Your Lordship. And on that basis, Your Lordship, I have prepared one calculation.
That's all?
Not,
Your Lordship.
in reply on, when it is in the judgment cited, it has not, it has stated may be taken if there are 2-3 returns of 2-3 assessment years. Then it apex court in the judgment which they have referred, it is stated may be taken. It is not mandatory that it is not judgment is written that it must be taken in all cases. At page 157, Lordship,
Yes.
it is stated may be taken. Not a dictum that it must be taken.
You see, there are so many judgments, Your Lordship, interpreting may be taken, Your Lordship.
Yes, yes.
So it is not mandatory, so our submission is that tribunal has rightly taken the average.
Please take down. The incident appeal is preferred against the judgment and award dated 27 November 2017, passed by Learned Judge Motor Action Claim Tribunal, Jalpaiguri in MSC case number 203 of 2015. Stop. The brief fact of the case is that the present appellants being the claimant filed an application under section 166 of MB Act before the Learned Tribunal for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle duly insured under the policy of the insurance company. The claim case was contested by the insurance company by filing written statement. After hearing the parties, the Learned Tribunal has awarded a sum of rupees
32 lakhs 2,000.
32 lakh 2,000
with default interest 9%.
towards the compensation and directed the insurance company to pay the compensation. Stop. Being agreed by and dissatisfied with the said award, the present appeal has been preferred. Stop. The Learned Tribunal for the appellant submits that the Learned Tribunal has not considered the entire facts and circumstances of this case, and the award was passed without following the law of the land. They argued that in this case, the Learned Tribunal has failed to consider the income of the deceased appearing in the income tax return. Learned Tribunal also not considered the future prospects and general damages according to the observation of the Honorable Apex Court in pronouncement. Stop. One crore regarding income. Other one headline income of the decision. The claim application stated the occupation of the deceased to be businessman and approx monthly income was 30,000. Stop. During the course of the hearing before the Learned Tribunal, the claimant has submitted the income tax return of the deceased, income tax return filed by the deceased prior to his death for the assessment year 2010-11, 2011-12, 2012-13, 2013-14, and 2014-15. Stop. Learned Tribunal has adopted the income of the deceased by averaging the income tax return. The income of the deceased was considered by the Learned Tribunal to be 3 lakh per year. Stop. next learned advocate for the appellant submits that the observation of Honorable Learned Tribunal regarding averaging the income of the deceased appearing in the income tax return is illegal by virtue of decision of Honorable Apex Court in Sasikala and others. Also, Sasikala and others versus Ganga Laxman and another within bracket 2015 9 SCC 150 and 2 Mollar VG and others versus United India Insurance Company Limited. The last year income of the deceased and which is higher has to be taken to be the just and proper income for assessment of the compensation in a case under section 166 of MPA. Stop. Learned advocate for the appellant, respondent insurance company raised strong objection and submits that the learned tribunal has correctly adopted the average of the income appearing in the IT return. Stop. The claimants has failed to appreciate any, has failed to prove any oral or documentary evidences to prove the occupation or income of the deceased. Thus, thus learned tribunal was justified in assessing the average income of the deceased. Stop. At the learned advocate peruse the observation of learned tribunal. It appears that in the assessment year 2010-11, the net income of the victim was 2,62,100, and in the year in the assessment year 2014-15, the income was rupees 4,97,320. The learned tribunal has averaged the income appearing in the IT return and fixed the income of the deceased to be 3 lakh per year. Stop. In the case of Sasikala and others, Supra, the Honorable Supreme Court has held that paragraph 8-9. In Mallarvaji and in Mallarvaji Supra, the Honorable Apex Court has also held paragraph 10 last paragraph. It is true that the Honorable Apex Court has held that the last year income tax return and which is higher has to be adopted to be the income of the deceased in calculating the compensation in a case under section 166 of MPA Act. After considering the entire facts and circumstances of this case, it appears to me that the deceased was a businessman. The business of the deceased has been sufficiently proved by the income tax return. Stop. A person who had no income, who would have no income, is not duty bound to file income tax return for consecutive years. Income tax return for consecutive years. Stop. Moreover, at the time of filing of the income tax return, it is the general notion of the public that he must file the income tax return showing the less income so that the tax liability may not be imposed upon him. Moreover, at the case of filing of the return, the deceased has no prospects of the death. Accordingly, I find no justification to consider the submission of the learned advocate for the insurance company. Moreover, the fixing income of the deceased appearing fixing average income of the deceased, fixing average income of the deceased, fixing average income of the deceased appearing in the income tax return was discouraged by the Honorable Apex Court in Sasikala and others. Accordingly, I find that the income assessed by the learned tribunal is erroneous. In this case, the assessment year of 2014-15 disclosed the income of the deceased to be 5,97,319. The tax liability of rupees 28,564 has to be deducted. Accordingly, the applicable income of the deceased for the purpose of this compensation, of the case of compensation, would be 5,68,755. Stop. Next part. Future prospects and general damages. Stop. Learned advocate for the appellant submits that the learned tribunal has not awarded the future prospects and general damages. Only rupees 2,000 was awarded towards the future funeral expenses. He submits that by virtue of decision of Honorable Apex Court. Is no funeral expenses. Only rupees 2,000 was awarded towards the funeral expenses. Stop. He submits that by virtue of decision of Honorable Apex Court in Massachusetts Compile Limited versus Pranay Sethi, the future prospect, the claimants are entitled to get the future prospects, which would be 40% upon his established income. Stop. He also submits that the general damages of rupees 70,000 has to be awarded in this case, and the claimants are entitled to get the 10% enhancement of the general damages as per observation of the Honorable Apex Court in Pranay Sethi. Stop. Learned advocate appearing on behalf of the insurance company submits that by virtue of decision of Honorable Apex Court in Divisional Manager Orient Insurance Company Limited versus Sapon Naik and others, 2017 ACJ 697, and by virtue of decision of Division Bench of the Calcutta High Court in National Insurance Company Limited versus Moina Ghosh and others, reported in 2017 ACJ 986. The learned tribunal has to assess the just and proper compensation of this case without specific evidence of the future prospects cannot be awarded. Stop. In this case, the same observation may be applicable, may be applied. Stop. Heard the learned advocate? Stop. The Honorable Apex Court in Pranay Sethi Supra has held that Pranay Sethi has held in a constitutional bench that there are several decisions of awarding future prospects throughout the India. Stop. Throughout the India. To solve the dispute, the Honorable Apex Court in Constitutional Bench, within bracket 5 judges bench, has held that in all cases of pending claim on all cases বলেছি না? In all pending cases and pending appeals. Pending cases and appeals. When the general damages and future prospects has to be awarded according to the schedule mentioned in the judgment of chronicity. Stop. In this case, in my opinion, the observation of Honorable Apex Court in Sapon Naik as well as the judgment of divisional bench of this court in Moinar Bose has overriding has no effect as the matter has been decided in a case by the Honorable Apex Court in chronicity. The constitutional bench in this matter has its overriding effect above and all the judgments on the same principle. Stop. Accordingly, in this case, I am of view that the claimants are entitled to get the future prospects, which will be 40% to the established income of the deceased and general damages of rupees 77,000. Stop. Considering the above observation, the award passed by the learned tribunal requires modification. Annual income. উপর লেখা দরকার না লিখে দিচ্ছি at future prospects 40%, 1/3 deduction, multiplier 16, general damages 70,000 plus 7,000, after calculation the award comes to rupees 85,70,408. Stop. The tribunal already granted 31,95,000. The balance comes to rupees 53,68,804. 68,804. The insurance company is directed to pay the compensation along with 6% interest per annum from the date of filing of the claim application till payment. Stop. Insurance company is further directed.
Another 6% on 30 lakhs, Your Lordship, because default interest.
Default interest.
Default interest, Your Lordship.
This is the last page, Your Lordship, page 27.
What default?
Your Lordship, within 2 months, last 3 months, within 2 months from this date.
No, that cannot be. Only the award shall carry 6% interest per annum. You can have the 6% interest only. Okay.
Your Lordship.
to deposit the above mentioned award through the office of the learned tribunal in the name of the claimants by paying two equal account paychecks. Stop. Within 6 weeks. Stop. The payment of compensation is subject to ascertainment of payment of deficit court fee, if any. The learned tribunal shall act upon the certified copy of this order to receive the deficit court fee, if any. FMAT connected can applications are already posted. Next matter after 2. Yes, come at 2 p.m.
You'll see,
Passport matter, how many matters are there?
3 matters I have, item number 10, 27, 27 and 20.
Okay. 10, 27 and 28.
Usually item 45, my landed friend is appearing. Same point, you'll see this matter from the same accident, this case is also filed and the same points here.
No, that has to be taken up. Otherwise, it
Your lordship.
mediation. Then cover next week.
Monday, your lordship, Monday.
Next
Monday.
আজকাল একটা আছে সেকেন্ড আগে পাবো ওটা সোমবারই করবে তখন বলেছে সোমবার তাহলে সোমবারে আমি নটিং করে সম্ভবত আমি বলতে পারি না বলে ওটা হ্যাঁ এখন কি উনি ওগুলো অনেক প্রশ্ন দিয়ে পারে আসে তাহলে সিনে রাখবেন হ্যাঁ কালকে অ্যাকাউন্টে দিচ্ছি কালকে আপনাদের
ওটা ওটা ও ডেট হয়ে গেছে ওরা সেকেন্ড অ্যাডমিট যেটা ও আরো অ্যাডমিট और আমি করতে বলি হ্যাঁ বলেছি বলেছি অবশ্য আমার বলতে বুঝতে পারবে না তারপর নিজের খবর নিলে কেসের কি আছে কত পয়সা দেওয়া হবে ঠিক 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 আছে ঠিক 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 আচ্ছা না না ওরকমই করতেছে পাওয়ার পাওয়ার হ্যাঁ 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 এগুলো আছে সম্পর্কে আমার ওকে একটা করে কপি কপি যেটা হলে কমপ্লিট ওরে বাবা ক্রিমিনাল ফাইল আছে এক্সপায়ার মানে ইম্পোর্টাম আমরা কি যাচ্ছি তাহলে একটা করে কপি কি সফল এক সিম্পলি যেন আসি বাকি পছন্দ না দিতে পারবে শুধু ফায়ার মান নিতে আনবেন ওটা কি দিন আনবেন ওটা আমার দরকার বাকি একটা স্টাইল কি লাগবে সেটা বলে ওইটা না সেটা দিতে না বলছি আর সঞ্জিত পেয়ে হ্যাঁ এরা সঞ্জিত পেয়ে আমাদের থেকে সব আছে দিদি বলতে সঞ্জিত এরা এরা বলতে বুঝছি নাই হ্যাঁ
যদি নিয়ে নেবে না তখন আর না বলেন
সোমবার মিশন
না এটা কোন হবে না এটা করবে ঠিক আছে আমি কি বলে দিই যদি অ্যাসেসমেন্ট শিট করে আমাদের লিখতে তাহলে আমি করে বলে দেই তাই কি করে হবে অ্যাসেসমেন্ট আপনি আমাকে অ্যাসেসমেন্ট শিট করে দিন দিয়ে যদি লোক আলাদা করতে হবে আগে থেকে দিয়ে দিই আমি করি ঠিক আছে যদি হয় তাহলে তাহলে কি আমাদের প্রিন্সিপাল করে অ্যাসেসমেন্ট শিট করা হ্যাঁ করাতে সুবিধাতে করা ওকে কাটা প্রিন্টি কম্পিউটার দিতে হবে না এটা অ্যাসেসমেন্ট কিভাবে কিন্তু দিবা আগে কম্পিউটার পাঞ্চ নাও করাটাই ঠিক না ঠিক আছে এই মুহূর্তে একদম কি হলো এই চলা একটা খুশি মতো করব না ওইটুকু অ্যাপ্লিকেশন করতে সব আর আমি নিজে আমি বলে দিই সেলিং থেকে একটু ওইটা সেটা আমরা এটা বলেছিলাম না আমার কথা আপনি জানেন সম্পর্ক অলমোস্ট আরেকজন এখন 43 থেকে একবার আচ্ছা হবে টাইম আছে আপনার এগুলো মেনশন করবেন না কিন্তু না 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 বলুন কেন রমারানি অ্যাটিটিউড ক্যান্সেল রমারানি সাফা করবে সাফা করবে যদি সোমবার দিন দিয়ে দেন তাহলে আমি করে দেব সাফা করব ঠিক আছে না না সম্পর্ক দেখা যায় এটা দেখে এবার বিকেল মধ্যে আনা করে সময় দিন থাকে ঠিক আছে
তাহলে আজকে পাবলিককে হচ্ছে কি অবস্থা? সব আছে নিয়ে আসছে আসেন বেশি নেই কেটে দাও আমাদের কমপ্লিট হয়ে গেছে কেটে দাও আমাদের কেটে দাও কমপ্লিট তারপরে আচ্ছা মানে একটা ও আগে কি মেইন শিটস গুলো আছে মেইন শিটস আমাদের মেইন শিটস এই টেকনোলজি টা ইমপ্লিমেন্ট করা হবে এই যখন তো ইন্ডিয়ান ইনস্টিটিউট মানে এই টেকনোলজিটা বিল্ড করেছে বুঝতে পারছেন আগে হবে we heard how if you look at how we mূল্যবান একটা ভৌতিক পাঠ করে দিচ্ছি আমাদের রাস্তা থেকে আসছে তাই তুমি কি আমি বলছি এখানে নাও so this is really from the knowledge we are in the we
That is my application, Lord. But very short point involved in this matter. Lord, whether the medical practitioners and Lord the related to medical practitioner, the nursing can be straight away FIR can be registered against them or not. Your Lordships knows better than me. There are two judgments which Lord standing on the way. One is in Jacob Matthew, which says you direct cannot register any FIR against the medical practitioner or the doctors or any nursing staffs. As because entire area is, so far as medical knowledge of the legal fraternity is concerned, is dark. There has to be a concrete opinion whether there is a medical negligence at all or not.
Yes.
So inquiry has to be conducted. And Lolita Kumari also says so. In this case, my lord, straight away, it's an unfortunate incident, no doubt. The son of the de facto complainant died. He was admitted in Neotia Hospital. Your Lordship knows Neotia Hospital is one of the best multi-specialty hospital in North region, this area. So his son was admitted in a nursing home with a chicken pox. As per the complainant, he was not properly treated. After 2 days, he was died. And proper explanation was not given to the de facto complainant. No doubt it's an unfortunate incident. But the FIR, your Lordship will find in page, but this is certified copy, but your Lordship will get that in page 27. The formal part is page 27 and the written complaint in page 28. But straight away, the police authorities, they have started the case. But I have covered by two judgments. One is the Jacob Matthew. But this is, if your Lordship allow me to place Jacob Matthew, para 52, and other one, Lord Martin D'Souza, which will, Lord, your Lordship will get the judgment about that. Martin D'Souza. Para 46 and 106. And even, Lord, your Lordship knows the recent position of law also. 5 judges bench of Lolita Kumari, Lord, they have carved out certain exception relating to lodging of the FIR.
Yes.
They says the preliminary inquiry is mandatory, this kind of cases, where there is a matrimonial dispute, where there is a medical negligence cases, where is a the delay more than 3 months. This is the
parameters.
Yes, parameters has been decided. So on that context, kindly stay the FIR for the timing and ask to serve copy up in the public prosecutor and your Lordship can fix a date for hearing. Very short point, and very recently, I must point it out before your Lordship, the similar issue just 1 month back, before the circuit bench only, before Malasis Khan, same issue has been decided against the same hospital where the FIR has been quashed on the same issue. Although this is a complaint case, straight away the judicial magistrate has taken cognizance as process was issued against the hospital and the concerned doctors. These two judgments were relied on and ultimately the proceeding was quashed. But this is a settled principle of law against the medical practitioner and doctor and the nursing staff. You cannot directly lodge any complaint. There has to be the inquiry committee which will give a concrete opinion regarding the cause of death. Then only the FIR can be registered.
Okay, please take down. The instant CRR has been preferred under section 482 of the Code of Criminal Procedure for quashing the proceeding being Matigada Police Station case number 190 of 2024 dated 22nd March 2024 under section 304 capital A of Indian Penal Code corresponding to GR case number 1006 of 2024 pending before the learned additional Chief Judicial Magistrate at Siliguri. Learned advocate for the petitioner submits that the present opposite party number 2 has lodged a complaint with the concerned police authority alleging inter alia the offence punishable under section 304A of IPC against the doctor as well as the
Hospital.
Hospital. Stop. It is the submission of the learned advocate for the petitioner that by virtue of decision of Honorable Apex Court in Jacob Matthew versus State of Punjab and another reported in 2005, 6 SCC 1, as well as Martin D'Souza versus Muhammad Isfaq reported in 2009, 3 SCC 1. Before initiate a criminal proceeding against the doctor and the hospital, one specific independent inquiry, preliminary inquiry has to be done. Stop. The said procedure has not been adopted in this case. So the proceeding initiated against the present petitioner is illegal in the eye of law. Stop. Having heard the learned advocate for the petitioners and also considering the ratio of law laid down by the Honorable Apex Court in Martin D'Souza as well as Jacob Matthew Supra, I am of a view that there are substance in the submission of the learned advocate for the petitioner. Accordingly, the instant criminal revision be admitted. Stop. The petitioner is directed to serve the copy of application upon the opposite party and file an affidavit of service on the returnable date. Let the matter appear in the list. May
May or June, let's skip May.
June. Okay. In the ensuing circuit bench for the month of June 2024. Stop. Next, considering the facts and circumstances of this case, the further proceeding of GR case number 106 of 2024 pending before the
1006.
1006 of 2024 pending before the learned additional chief judicial magistrate and investigation thereof by the investigating agency be stayed till the 26th day of July 2024 or until further order, whichever is earlier.
Deeply obliged. It's a very small matter. There is a civil dispute by and between the parties regarding a shop. First, we lost the complaint. Your lordship will get that in page 113, 113, under section 379. But
no, this is also motion stage.
This is also motion stage.
Okay.
First, we lost the complaint. Your lordship will get our complaint in 113. Formal. We lost the complaint. Oh, this is start हो गया है बार क्वेश्चन है एक पेज है दूसरा पेज Lord, this is on basis of that the FRA was started. Your lordship kindly get the reference, the reference number. This is Matigada police station case number 102 dated 15/2/2024 under section 406 420 379. This is my complaint.
Okay.
15th of, Lord, kindly mark this, 15th of February, this complaint was lodged. Xerox होना चाहिए if they're under challenge.
15th of
February,
yeah,
2024. Lord, sections I have also quoted, my lord, before your lordship. These are the sections on which 420, 406 and 379.
Yes.
After 2 days, that is on 17, a case was started against me. Your lordship will get that. This is a certified copy under section 341. Only non-bailable section is 341. Your lordship knows 341 pertains to wrongful resting. But here, what the complaint is alleging that she was stopped to go certain direction on a road. But that will not tantamount to your lordship knows that than me. It has to be in a confined place. 341 will be applicable. In a road, 341 cannot be applicable. So this is the only non-bailable sections. Otherwise, other sections here, non, the
325.
yes, non-cognizable. So FR cannot be started against it. I am on that. Can you stay the FR for the time being and let me sub copy and the complaint may be sub. Deputy is non-bailable and cognizable. No.
Okay, please take down. This is an application under section 482 of the Code of Criminal Procedure for quashing of the FIR and the entire proceeding arising out of Matigada Police Station case number 112 of 2024 dated 17/2/2024 under section 341, 323, 506, stroke 34 of IPC corresponding to GR case number 569 of 2024. Stop. Learned advocate for the petitioner submits that the instant police case is initiated, is the counterburst of on earlier case, police case being number
Matigada police station case number.
Matigada police station case number.
This one. But this is 102.
102 of 2024 dated 15/2/2024.
406, 420, 379,
102 of 2024 dated 15th of February 2024. Under section
406, 420 and 379.
420, 406 and 379 of IPC. Stop. He submits that the allegation in the FIR is false and concocted. If the proceeding is allowed to be continued, that would be the abuse and process of court. That would be an abuse of process of court. Stop. Having heard the learned advocates and considering the body of the application along with the connected annexures thereof, it appears to me that there is a good arguable case. So the instant criminal revision be admitted. Stop. The petition is directed to serve the copy of application along with a copy of the petition along with the annexes thereof to the opposite parties and file an affidavit of service on the returnable debt. Considering the facts and circumstances of this case, the further proceeding of GR case number 569 of 2024 as well as the Matigada police station case number 112 of 2024 dated 17/2/2024 be stayed till 28th of June 2024 or until further order, whichever is obvious. Let the matter appear in the list in the ensuing circuit bench for the month of June 2024.
But this matter, that department was supposed to serve the copy to the respondent authorities. But this is an application 482 read with section 226. Certain directions were passed against the respondent authorities by the earlier bench. But the department was supposed to serve the copy. I find that the service is not complete. So let it be the service will be done by the department, and for the time being, let it be out of the list, liberty to mention.
Department was directed.
Yes, notice was issued. Milad, your lordship fine.
Issue notice.
Issue notice. So it has to be by the department. Otherwise, Milad, we are supposed to direct it.
Issue notice of what?
Issue notice. The petition. Milad, notice. Milad, Manasis Kant has passed the order. Your lordship knows the usual practice in Delhi High Court, like Supreme Court. When any Milad, other side is being heard, then issue notice. The department, it is duty of the department to serve.
But here you are.
The advocate is supposed to provide. Whatever, if your lordship direct me to serve, we will serve. For the timing, let it be out of the list.
Okay. Please take down. This court video order dated 15th of March 2024 directed the department to issue notice to the respondents. Stop. The order was not complied. However, for the purpose of hearing of this appeal, the petitioner is directed to serve the copy of petition along with the annexes thereof to the respondents and file an affidavit of service on the returnable date. File an affidavit of service. Stop.
Liberty to mention.
Let the matter be go out of the list. Parties are at liberty to mention.
Declare. Deeply obliged. But again, my lord, I apologize for my delay. I missed my first flight, which was 8 minutes, my fault.
I understand.
Then, my lord, I had to come, my lord. Next flight.
Item 44. Smile.
My lord, in this matter, I am appearing on behalf of the insurance company, my lord. So paperwork I have not received, my lord. So let it be fixed on Monday, my lord. I will appear.
Shall we make it on Monday?
Monday.
Monday.
You have the paper book.
So, sir, here now.
Yes. Monday. Next.
45 minutes already fixed on Monday.
Monday. Okay.
47 and 48.
Yes. My lord, I am appearing on behalf of the applicant, my lord. Well, there are two appeals in this matter, my lord. There is a appeal and cross appeal. And both the matters require to be heard analogously, my lord.
Where are the other? This is 47 of 2020.
47 is my appeal from the side of the.
Prepared by the insurance company.
Yes. 47.
47 is the appeal on behalf of the insurance company.
Insurance company.
And what are the appeal for 28?
44.
44. 28.
28, right.
LCR is there?
Yes, LC is there. But a short point of appeal, my lord.
Let me hear first the insurance company.
Okay, madam.
And who is appearing for the claimants?
I am appearing for the claimants.
You are appearing for the claimants?
Yes, my lord.
And you are appearing for the insurance company?
Insurance company.
Very well. So what, who shall start first?
May I start, my lord?
Yes, you can start.
My lord, actually, this judgment was passed. 22nd December of 2022, my lord. Till date, no payment has been made from the side of the insurance company, my lord. Though the judgment was passed in the year 2022 on 22nd December, my lord. No, that award has not been satisfied by the insurance company, my lord. The short point of appeal, my lord. Tribunal in this matter, my lord, tribunal did not assess 25% of the future prospect, which is bad in law. So far, the judgment of the Pranay Shetty, my lord. 25% of the future prospect has not been considered by the tribunal.
What is the date of accident?
Date of accident, my lord. Date of accident. Date of accident. 24th January 2017.
24th January 2017 is the date and succumbed to his injuries on 27th.
Yes, my lord.
Yes.
My lord. Next point, my lord. 7% interest has been awarded by the learned tribunal. Though it has been mentioned that there is a default clause, my lord. Their default interest clause. If the amount is not satisfied within the stipulated period, the entire awarded amount will carry 9% interest from the date of filing.
Yes.
It has been mentioned, madam. Number 3, my lord. Loss of estate. It's a settled principle of law. So far, the judgment of the Constitution Bench. The loss of estate should be 15,000 and funeral expenses should be 15,000. But here in this case, only 10,000 each has been considered. So these are the infirmities in the judgment, my lord. So this is required to be modified. and 10% extra has not been added.
And apart from that, you don't have any.
No, I don't have any other.
So you have the future prospects and general damages.
Future prospect general damage has been awarded, but only 10,000 each.
Okay.
And award not has been satisfied till date, my lord.
Yes. Very well. And for the insurance company?
There is a 3-day delay affair.
Only 3 days.
3 days delay affair and motorcycle dash a person. So insurance company please that the vehicle without heavy vehicle this cannot be happen. So there is a chance of
No. It is not possible to follow. You are arguing very sharply.
Actually, we have
Where is the FIR?
FIR, my lord, page number 33 of the paper book. Written FIR paper book from page number 33.
33.
My lord. Why 3 days delay? That has been, reason has been assigned at the end.
So it has been stated that one motorbike being
Motorbike.
number AS 17E3879 was dashed.
Yes, my lord.
So this is the fact of FIR.
Yes, my
So
lord.
what is your submission?
submission is that the a great injury matter happened without heavy vehicles.
Presumption, my lord.
No. Where from you are getting this?
No, this is our
No. You have raised you have filed the appeal on the ground of non-involvement.
non-injury.
Is there anything material regarding whether you have called any witness or like that?
Not injury.
No. Okay. No. Where from you are submitting that? Is there any PM report like that?
No, not actually, not that.
Is there any injury, severe injury which can be?
If there is a severe injury, head injury, and this type of injury, so our presumption is that presumption.
Right, abstract hypothesis.
No, it's our presumption.
Okay. Okay. So your submission is that the bike, that is the offending vehicle, so-called offending vehicle, was not involved.
Not involved.
The deceased must have dashed by a heavy vehicle. This is your submission.
And because there is a 3-day delay, so there is a chance of
The reason has been.
the owner and the
Okay.
My lord, kindly see the FIR at the bottom of the FIR, my lord. It has been categorically mentioned why the delay has been caused.
Okay.
And the number which has been mentioned, my lord.
Let him finish. You have your chance in reply.
Yeah.
Yes. Any other ground?
and no charge sheeted witness has been one another point is there.
That is the
Tribunal relied upon the opinion of
PW2.
only two.
PW2?
And there is no charge sheeted witness was examined before the tribunal.
Now, where is the PW2? Refer me the page.
Page 12 to 14 of the paper book. 12 to 14. Of my paper book, my lord.
12 to 14. Cross examination
Yes.
at page 14.
14.
Very good.
Any? No. That the tribunal blindly relied upon the evidence of the OP2 and interested witness and not even a witness of charge sheeted witness and held that the deceased has died on the accident.
Okay. He's an interested witness.
Interested.
Why whether he is a relative?
Because he is a known.
There is no whisper in the
No,
record.
I want anything, any material is there, just. Okay. That's all?
Yes.
My lord, may I please?
Yes.
Well, first of all, actually, the reason of delay of lodging the affair that has been mentioned at the bottom of the affair, that is page number. At the written complaint. Page number 33, last line.
Okay, just wait.
My lord. Number two, my lord, regarding their claim actually, whether it was a interested witness or not. So there is a cat and mouse judgment of the Honorable Apex Court, my lord. Your lordship, being an experienced judge, knows it better than me, my lord. They have not, from the side, from their side, from the side of the insurance company, they have not adduced any witness. They have not produced any witness from their side to controvert the evidence of the prosecution witness, the petitioner's witness or the eyewitness, the statement to contradict the statement made by the eyewitness. Nor they have summoned the driver of the offending vehicle, nor they have summoned the owner of the offending vehicle. So they have not done nothing. Even they have not filed any additional written statement. Nothing. Even in the cross, if your lordship kindly have a look at the cross examination, it's a very statutory, it's a very stereotype cross examination.
It's a cryptic cross.
Cryptic, my lord. So
Very hard. Please take down.
Well, this is the assessment of compensation, my lord. From my side, I have given an endeavor to make it.
How many claimants are there?
Four claimants, my lord.
Who are they?
Four claimants, mother, wife, and two minor daughters.
Two minor daughters. Total four. That's why 1/4 deduction.
1/4 deduction, my lord.
Okay, it was also done by the learned tribunal.
Yes, my lord.
Multiplier would be?
Multiplier would be
14.
14.
Age is 42
41
years.
years. 14.
41 to 45 years.
Yes, my lord. As per Shaula Verma.
Very good. Please take down. Both the appeals have been preferred against the judgment and award dated 22nd day of December 2023, passed by the learned judge, Motor Accident Claim Tribunal.
My lord, 22, my lord.
22nd day of December 2023.
22, my lord.
22.
Yes, my lord.
Your memo stated otherwise. 22. Your memo is incorrect. Very well. 22nd day of December 2022, passed by the learned judge, Motor Accident Claim Tribunal. In MSC case number 167 of 2017. Stop. The fact of the accident is that on 24th of January 2017 at about 7:20 a.m., while the victim was standing by the roadside at Deben
Babur Choupati.
Choupati. Deben Babur Choupati. Kamaksaguri.
Kamaksaguri under PS Kumargram.
Under PS
Kumargram.
Kumargram. At the time, one motorcycle bearing number capital AS-17 -E -3879 coming at a high speed from Bochamari dashed down the deceased, and as a result, the victim sustained severe bodily injury, and he was taken to the Kamaksaguri Primary Health Center and they are shifted to the Alipurduar Hospital. The attending doctor declared him as dead. Declared him dead. Stop. The present petitioners, appellants, present appellant claimants, being the legal heirs of the deceased, preferred an application under section 166 of MBI before the learned tribunal for getting compensation on the ground that the deceased died due to the rash and negligent driving of the driver of the offending vehicle duly insured under the policy of the insurance company. Stop. The claim case was contested by the insurance company by filing written statement. The insurance company also filed the application under section 170 of the MP Act, and they have been allowed by the learned tribunal to contest the claim case on all available grounds. Stop. After perusing the material, after receiving the evidences and after heard the learned advocate for the parties, the learned tribunal has awarded a sum of rupees
40 lakhs 4025,066.
40 lakhs 25,066
Along with 7% interest.
together with 7% interest.
Yes, madam.
Together with 7% interest towards the compensation and directed the insurance company to pay the compensation. Stop. The next one. The insurance company as well as the claimants have preferred two separate appeals against the same award. Stop. Both the appeals are taken up together for uniformity of the judgment. Stop. Next paragraph. The grounds adopted by the insurance company in the appeal is as follows. 1. The offending vehicle, the so-called offending vehicle, was not involved in the alleged accident. 2. The observation of the learned tribunal only on the basis of so-called eyewitness is illegal. Stop. Next paragraph. The claimants have preferred the appeal only on the ground that the learned tribunal has not considered the observation of Honorable Apex Court in National Insurance Company Limited versus Pranay Sethi to award the compensation on the grounds of future prospects and general damages. Stop. Next paragraph. Non-involvement of the offending vehicle. underline code. Learned advocate for the insurance company submits that the so-called offending vehicle, that is the vehicle, that is the motorcycle bearing number AS 17E 3879 was not at all involved in the alleged offense. He submits that the FIR was lodged after 3 days of the accident. Stop. The claimants perhaps contacted with the owner of the so-called offending vehicle to arrange the entire case against the insurance company. He further submits that the learned tribunal has not considered the issue and passed the improper award. Learned advocate for the insurance company further submits that from the facts and circumstances of the case, it would be seen that the injury sustained by the victim is so grievous that only the light vehicle such as motorcycle cannot be involved in the said accident. Stop. Learned advocate for the claimant submits that the argument on behalf of the insurance company is not substantiated by any materials. Moreover, insurance company has not proved the same before the learned tribunal. He further argued that the insurance company also not called the driver or owner of the offending vehicle to contradict the case of the present petitioners. So the argument advanced by the learned advocate for the insurance company cannot be entertained. Or the learned advocate peruse the materials on record. It is the argument of the insurance company that the offending vehicle was not involved in the alleged accident. Stop. The FIR of the incident case was lodged with the Kumargram police station, Kumargram outpost, the Kumargram outpost on 27/1/2017. Stop. It appears that the brother of the deceased has lost the written complaint. Stop. It has been stated in the last paragraph of the said written complaint that the due to the final rituals of the victim, they could not file the written FIR within time. There are only 3 days delay, and it is general principle that the relatives of the victim must have engaged themselves to perform the last ritual of the victim. So I find no justification in the delay of 3 days.
May I interrupt, my lord, 1 second? Actually, it will be Kamakhaguri outpost, my lord, not Kumargram outpost.
Kamakhaguri?
Actually, to the IC, Kumargram PS, through Kamakhaguri outpost, but
okay,
it will not be Kumargram outpost, Kamakhaguri outpost.
Kamakhaguri outpost.
Yes, madam.
Through Kamakhaguri outpost. Kumargram outpost বলেছেন এটা Kamakhaguri outpost. কি বল? Next one.
Numbers of the victims find no justification in the delay of 3 days.
No, I find justification. No, I find justification in delay of 3 days in lodging the FIR. Stop. However, it appears to me that the division bench of this honorable court in Mita Samanto has been specifically observed that when the insurance company has taken the liability of the owner of the offending vehicle to contest the claim case on all reasonable grounds, the insurance company has the liability to prove the non-involvement of the offending vehicle. Insurance company has the liability, insurance company
has the liability
to prove the ground of non-involvement of the offending vehicle. Prove the ground of non-offending vehicle by calling the owner or the driver of the offending vehicle on dock. In this case, it appears that the insurance company has not adopted the procedure. So, in my view, the plea and the argument advanced on behalf of the insurance company has no leg to stand upon. So, the first ground for filing the appeal on behalf of the insurance company is found on. Next, headline karo. Regarding the value of evidence of PW2, the insurance company, the learned advocate, the insurance company submits that the learned tribunal has abruptly believed the evidence of PW2 stop. He further submits that the PW2 is not the CS witness of the police case initiated on the basis of the said accident. So the evidence of PW2 cannot be believed. Stop. Learned advocate for the claimant submits that the PW2 initially examined in chief, thereafter he was cross-examined by the insurance company. Stop. The credibility of the evidentiary value of the PW2 has not been shaken by the insurance company by putting specific question or suggestion in the cross-examination. So the person of PW2 cannot be disbelieved. Had the learned advocate peruse the materials, also peruse the PW2, peruse the evidence of PW2. What is the name? PW2.
Sushil বিশ্বাস. Sushil বিশ্বাস. 12 to 14 page number.
Sushil বিশ্বাস. Sushil বিশ্বাস. It appears that the PW2 Sushil বিশ্বাস is cited as CS witness number 2 in the charge sheet. So it appears that the argument on behalf of the insurance company is not justifiable. Accordingly, the same is turned down.
Okay. My lord, rightly mentioned, my lord, I missed that point, my lord.
Next one. Next one. Learned advocate for the claimant submits that the learned tribunal has not awarded the future prospects and general damages by virtue of the decision of the Honorable Constitutional Bench in National Insurance Company Limited versus Panama City. Learned advocate for the insurance company has not argued anything on that point. Stop. It appears to me that in the month of September 2027, Honorable Apex Court had set out 5 judgments to be a constitutional bench to fix the general principle for awarding the compensation in a case under Motor Vehicles Act. It has been settled by the Honorable Apex Court that in all cases of compensation under 166 of MD Act, the future prospect has to be given to the claimants considering the age of the deceased. Stop. Considering the age of the deceased and the nature of their occupation. Stop. In this case, the deceased was within the age group of 41 to 45. So the 45, and he was not in a permanent job. Thus, the future prospects, according to the observation of Honorable Apex Court in Brunei City, the claimants are entitled to get the 25% addition to the established income of the deceased. It further appears that next report, the learned tribunal has awarded the general damages under the head of
Loss of
funeral expenses, loss of estate, and loss of consortium. It appears that the funeral expense and expenses and loss of estate was awarded rupees 10,000. According to the observation of the Honorable Apex Court in Pranay City, the funeral expenses and loss of estate would be 15,000 each. Stop. Next one. Considering the above aspect, the award passed by the learned tribunal requires modification. After calculation, the award comes to rupees 50,26,326. The award shall carry 6% interest per annum from the date of filing of the claim application.
My lord, 7%.
No,
My lord, 7% awarded already, and
I understand.
Just only.
From that is from 17/4/2017 till actual payment. Stop. The insurance company is further directed to pay the compensation together with the interest through the office of the learned tribunal within 6 weeks in the name of the claimants by equal 4 account paychecks. Stop. The payment of compensation is subject to the ascertainment of payment of deficit court fee, if any. Stop. The learned tribunal shall act upon the certified copy of this order to receive the deficit court fee, if any.
There is a 25.
Both the FMAT, both the appeals along with the connected applications are disposed of.
Liberty should be 25,000 statutory deposit there.
You have deposited the 25,000 statutory deposit.
You withdraw that.
No. Your appeal being appeal number FMAT
FMAT 47.
47.
Yes.
Give me the challan. No, it has been noted by the account section that nothing has been deposited.
Oh my lord, see. After that. Xerox copy and.
Yes. The insurance company is at liberty. Insurance company is at liberty to withdraw the statutory deposit of rupees 25,000, which they have deposited during the pendency of the during the pendency of the FMAT MB 47 of 2023, wide OD challan number 114 dated 4/10/2023. Stop. The office of the registrar, Circuit Bench, Calcutta, Circuit Bench of Calcutta High Court at Jalpaiguri, Calcutta High Court, Jalpaiguri, shall disburse the statutory deposit along with the accrued interest to the insurance company.
Grateful, my lord, deeply grateful, my lord. Grateful.
Okay.
এই আমাকে দিয়ে